Hey guys, this is attorney Toby Mathis from Anderson Law Group and Business Advisors. And today I wanted to talk about real estate and estate planning, and specifically how to screw up your real estate when doing an estate plan. And I'm going to kind of go through this in a few different ways. Subscribe to the YouTube channel, click the bell notification icon so you know when a new video is uploaded. Tax laws are changing all the time. The laws are changing all the time. That's why you're first to know, you're first to grow. First off, if you own real estate and you do not put it in some sort of entity when you pass away, it's absolutely guaranteed to go through probate. It's going to have to go through a process which by all estimates will take a chunk of its value and take somewhere between 6 and 18 months. And I'm giving you a broad stretch because about the lowest you're going to be able to see it get transferred in is 6, and the average is about 18 nationwide. But if all you had was a piece of property that was held in your name, you might be okay. Now, here's the problem. Everywhere you own real estate is subject to that same rule, which means every state requires probate. So if I own real estate in multiple states and I do not put it in a correct plan, I don't use an entity, I don't use my land trust, my LLCs, and my living trust. If I don't use these things, then I am going to force my heirs to go through a process where they're required to go in front of a judge in every state where I have the real estate. So if it's in 3 different states, I am looking at 3 different probates, which means more likely than not that I'm going to end up with 3 different lawyers or law firms charging me 3 different fees just for the sake of transferring property. Now, before you say that doesn't happen, I will say my personal experience in this was that my grandmother passed away with properties in 2 different states. They were just lots. One was a lot with a home on it, and the other one was just a lot in Alabama and Florida. And it was less expensive to let them go back to the state than to deal with the rigmarole of going through the transfers. And it wasn't my problem that I had to deal with. It was her son's, which was my father's responsibility in having to deal with that. And he was shocked. These were not valuable pieces of real estate. But even so, even though it should have been simple, all lawyers are going to tell you, probate in my state is simple. It's not cheap. It's not quick. And when you involve real estate, it's not any of those things. It's not cheap, it's not fast, and it's certainly not simple. Otherwise, they wouldn't be charging you these big fees that they charge. Now, the solution is actually very easy. If you put a piece of property, if nothing else, just use trust, you're going to avoid probate. You're going to avoid it by making sure that you have beneficiaries who get that property after you pass. There is another way to do this, which is a paid on death or a joint tenants, but I tend to avoid those simply because they don't stop some of the little nuisances that can pop up. For example, somebody predeceases you, then it didn't do you any good. If you give it to somebody who has some financial issues, doesn't do you any good. If I'm a joint tenant on somebody and I want to transfer it, now I have to get their approval. You get all sorts of little issues. And I've actually seen that occur on more than one occasion. The last one I saw was somebody who got remarried, and they had a piece of property where they added one of their children, and they needed the child's approval to transfer it back into the estate plan to go to mom, and the child never did that. And as a result, the child ended up with the property at the expense of the mom, who they'd been married for a long period of time, and all of a sudden she doesn't have a home. And she's relying on the child to decide it's okay, you can still stay there, which is not a comfortable situation. In this particular case, they said no, not a pleasant situation at all. So I tend to say, whenever we're dealing with real estate, it's better to have your plan in writing and to avoid courts. You know, the old adage was, what do you call an attorney with an IQ over 70? Your Honor. So you want to avoid the judges. You don't want to go to court. And there's a surefire way to go to court when dealing with estate planning, which is to do nothing or to do a will. And I don't want either one of those. What I'm going to do is opt for using a trust. Now, if you've heard Using LLCs for asset protection? Absolutely. LLCs are fantastic asset protection tools. They work great with tax planning and a whole bunch else. Absolutely. But at a minimum, we want to have a trust. And an LLC by itself will not get the job done. We need to have a living trust for our estate plan. And in a living trust, if all we were looking at was estate planning, if we didn't care about asset protection or tax planning or anything else, if all we wanted to do was make sure that an estate avoided going through the court process and avoided probate, then what I would end up doing is a living trust. Simple. And I would just put those properties into it. And if I had properties in 10 different states, guess what? I'm not probating in those 10 states. The properties are already held in trust. And a trust, just to make it real simple for you, really has three parties. You have a grantor, or the person who starts it, settlor, however you want to term it, the person who gives the asset to the trust. You have a trustee. That's the party who oversees that asset and makes sure that it's used for the benefit of, number three, the beneficiaries. Now, here's the beautiful part about a living trust. During your lifetime, you can be all three, and you can change them out. It's revocable. You can completely change it anytime you want. Once a triggering event occurs, which is going to be either your incapacitation or you pass away, it becomes irrevocable. Now we just go down succession. Who's going to be the next trustee? Who's going to be the next beneficiary? We don't need a new grantor because you've already put the property in there. But now the trust owns it, and we don't need to go to court because we already have these things designated. And you don't have to name specific individuals. You could use a trust company. For trustees, you could use individuals, then trust companies. The other route you can go on beneficiaries is to use a term of art like descendants. Hey, it's going to go to my descendants. And maybe I'm not even going to distribute the assets. Maybe it's just going to be held in trust for the benefit of my kids, my kids' kids, my kids' kids' kids, etc. And you could even put specific purposes. They're absolutely fantastic vehicles. But for real estate, it's just very important that we make sure that we're not just leaving this stuff to chance. Worst thing you could possibly do is to own real estate in multiple jurisdictions in your name. Just don't do it. Make sure that at a minimum, you have a living trust. And the best practice, as anybody who's in this world that's in real estate extensively will tell you, is to use an LLC to hold properties. Sometimes it's one per LLC. Sometimes there are situations where you might have others, especially if you're dealing with commercial lenders. But you're going to want to talk to somebody knowledgeable on this. So I hope this helps you make better decisions, especially when it comes to estate planning and real estate.